Uganda versus Malay H. Mabirizi, H. Wanuka. You're a male adult, aged 39 years, a Muganda by tribe, a lawyer, a resident of Mulago Chiwavu Zone, Kawempe District, Kawempe Division in Kampala District. On count 1, the statement of the offense is malicious information contrary to section 28(1) and 2 of the Computer Misuse Act, Cap 96. The particulars of the offense are that you, Malay H. Mabirizi, H. Wanuka, during the month of January in the years in Uganda, including Kampala and Wakiso districts or thereabout, using a computer via TikTok account at malay.mabirizi, sent, shared, or transmitted information about or relating to the Honorable Chief Justice Zeija, the Chief Justice of Uganda, that he is a conman and fraudster, corrupt, sold off his property to pay a bribe for his appointment as principal judge of Uganda, and a court file grabber, whereas not. Have you understood the charge?
Yes. False.
And count 2. Speech contrary to section 26(1)(a) and 2 of the Computer Misuse Act, Cap 96. The particulars of the offense are that you, Malay H. Mabirizi, H. Wanuka, during the month of January 2026, at various areas in Uganda, including Kampala, Chief Justice of Uganda, that he is a conman and fraudster, corrupt, sold off his property to pay a bribe for his appointment as principal judge of Uganda, and a court file grabber, which information is false and is likely to ridicule, degrade, or demean the said Honorable Chief Justice Zeija. Have you understood that?
I pardon the section.
That's contrary to section 26(1)(a) and 2 of the Computer Misuse Act, Cap 96. Did you understand that?
This is hate speech.
Yes, the offense is hate speech. Did you understand that?
Yes.
Is that true or false?
False. No,
Count 3. The statement of the offense is malicious information contrary to section 28(1) and 2 of the Computer Misuse Act, Cap 96. The petitions or thereabouts, using a computer via TikTok account at malay.mabirizi, sent, shared, or transmitted information about or relating to Honorable. Have you understood that?
I've heard that.
Is that true or false?
False and not agree.
And on count 4, the statement of the offense is hate speech contrary to section 26(1)(a) and 2 of the Computer Misuse Act, Cap 96. The particulars are that you, Malay H. Mabirizi, H. Wanuka, during the month of January 2026, at various areas in Uganda, including Kampala and Wakiso districts or thereabouts, using a computer via TikTok account at malay.mabirizi, sent or shared information about or relating to Honorable Justice Musa Sekana, a Justice of Court of Appeal of Uganda, that he is a conman and fraudster, which information is false and is likely to ridicule, degrade, or demean the said Honorable Justice Musa Sekana. Have you understood that?
Yes.
Is that true or false?
False and unconstitutional.
Plea of not guilty is entered on count 1. A plea of not guilty is entered on count 2. A plea of not guilty is entered on count 3. And
Much obliged, Your Worship. Your Worship, the inquiries in this matter are near complete. We seek an adjournment for a mentioned date, although we shall inform court on the status of investigations then.
Considering the investigations are not complete, state is not ready to proceed with the case. The fact that we've also received instructions from this person to apply for bail pending the hearing of this case. We pray that you allow us to proceed with the bail application.
Have you uploaded your bail documents on it?
At the time the file was brought here, it had not been uploaded on the system. Even while when we came to appear in court, it wasn't there. Right? Because it wasn't on the system. So we decided to come up with safe. That's why we need to have the case number to determine interview. But we have the documents here and we are able to proceed.
Also, I advise you to upload the bail application documents on ICNIS to enable court handle your application. And the accused is remanded.
Your Honor, for clarity,
Yes.
whether to upload a form application.
You choose whether form or if not, just upload the documents of the sureties. The accused is remanded until 18th February.
Your Worship, we wish to put court on notice that the matter has not been entered onto the system.
The matter
we
is on the
believe
system.
it had been done. If that is the case, we have a laptop. We pray that we be allowed time to have the documents filed, because this is a constitutional matter. The right to apply for bail, just to apply.
I
It's
understand.
merely applying, and we just want to have that right.
And so
enforced.
I have guided that you upload your bail application documents onto ICMIS. The number is 52 of 2026. You will apply for bail at the next hearing.
Your Worship,
The matter is adjourned until
if I-
18th February.
if I may come in, as an
Thank you.
Much obliged, Your Worship.
With all honesty, there is no justification. I hope the thing is recording me, because it's just moving off.
No, but you have.
It's recording.
No.
It is.
So this matter is coming up for plea taking, and with all honesty, there is no justification for counsel to pray for a standover. Unless my president is seeking instructions from the accused person. Our assumption as prosecutors is that before anyone appears before court, they have duly been instructed to appear on behalf of the accused person. So our plea is that this matter proceeds with the plea taking, then the rest. Counsel can sort themselves out with the accused person. This is my first time I'm experiencing a standover for plea-taking. And I hope our brothers appreciate our objection. You know, even a accused person can be remanded without plea-taking. In the event, Your Worship, that you are inclined to grant the standover, then it should be a standover of 2 minutes. Just only 2 like this. They're enough. But on the other hand, we implore Mr. Mabirizi to be courteous to court, so that we proceed in a professional way before this court. Let us avoid being personal. There are issues which we can raise if they are really substantial and inevitable, that you can raise them in an organized, professional, respectful manners or way. Otherwise, I'm seeing as if we are going too personal, which will make the situation look awkward before this court. We so submit.
There is no limit to legal representation. The accused person has a right to legal representation, a constitutional right, Article 28. And even during the proceedings, the accused person is allowed to conference or confer with the advocates. And then I must also bring it to attention that before bringing him here, he was in police custody, where access was actually very limited. And also, Your Honor, it is in the interest of this court and justice that the accused person, Mr. Mabirizi, is allowed to conference with the 3 advocates here. So that we are able to communicate a common position.
Okay, without wasting time, Counsel, I'll give you 2 minutes or 1.5 conference with our client right here. I will stay here. Just do that quickly and let's proceed. Because we need to get done with this.
That's right.
Let's go down. Okay, that's why. Take us over.